Welcome to our deep dive on the risky business of suing the government over immigration processing delays through a writ of mandamus. First, we will frame the real-world problem of long waits for I-485 green cards and I-765 work permits. Then, we will explore what a mandamus action is, why pro se filings are uniquely dangerous, how government attorneys respond, and what the cost-benefit analysis looks like. Finally, we will offer practical steps and a clear summary, along with a brief quiz to reinforce key points. To set the stage, our agenda covers 8 parts: the context and impact of delays, what a writ of mandamus is, pitfalls for self-represented litigants, the legal standard required to survive dismissal, how these cases typically unfold, the cost-benefit reality, practical pre-filing steps, and finally a brief quiz and key takeaways. Next, let's define the writ of mandamus. A mandamus action is a federal lawsuit requesting a court to compel a government agency to perform a clear, non-discretionary duty. Importantly, it is not a customer service ticket or an administrative inquiry. It is serious federal litigation. The goal is to prompt a decision, not to guarantee a specific outcome on the underlying application. Now let's look at the landscape of delays. Adjustment of status applicants frequently experience months to years of waiting for essential benefits, such as I-485 green cards and I-765 employment authorization documents. These delays can cause prolonged unemployment, lost income, and significant personal and family stress. Given these stakes, some applicants consider filing a writ of mandamus to compel agency action. Moving forward, here's how a writ of mandamus fits among other options. When an extreme delay occurs, applicants might try service requests, congressional inquiries, or expedite requests. A mandamus lawsuit is different because it initiates formal federal litigation. Once filed, the government may either act on the application or respond with a motion, often a motion to dismiss. If the agency acts, the lawsuit may become moot. If not, the plaintiff must oppose dismissal or amend the complaint. Moreover, let's compare self-representation to hiring counsel. Pro se litigants may save on upfront fees, but must draft a legally sufficient complaint and then respond to procedural and substantive motions. The margin for error is narrow, and the risk of dismissal is high. Experienced attorneys, by contrast, can articulate the legal theory precisely, anticipate defenses, and navigate federal procedure, though this does require upfront funds. However, it is essential to understand the legal standard. A mandamus complaint must allege that the agency has failed a clear, non-discretionary duty imposed by law. Simply asserting that the wait has been too long is not sufficient. The complaint must also request specific relief, typically compelling the agency to make a decision, not directing a particular substantive result. If the legal theory is underdeveloped, the government will likely file a motion to dismiss for failure to state a claim. Courts often analyze reasonableness factors to assess delay, and the plaintiff must address these standards in the pleadings. Next, let's visualize a typical timeline. At day 0, the plaintiff files the complaint. Over the following weeks, service is completed. Within 1 to 3 months, government counsel usually appears. Around 45 to 120 days, the government often files a motion to dismiss or a status report indicating action. By 60 to 150 days, the plaintiff must oppose the motion or file an amended complaint. Between 90 and 210 days, the court may rule, or the parties may stipulate to dismissal. At any point, the agency might adjudicate the underlying application, potentially mooting the case. Furthermore, consider a simplified, illustrative cost table. Lost wages without employment authorization might be $2,000 to $5,000 per month or more. Federal civil filing fees are currently several $100s. Attorney retainers for mandamus litigation can range from a few thousand to significantly higher, depending on complexity. Pro se drafting and opposition can require 20 to 60 or more hours of intensive legal work. These figures are examples, not quotes, and actual numbers vary. Now, a quick knowledge check. The question is, which element is most critical for a writ of mandamus complaint beyond stating that the wait has been too long? Option A, demonstrating emotional distress and hardship. Option B, alleging a clear, non-discretionary duty and requesting specific relief. Option C, showing you contacted customer service multiple times. Option D, including every date you mailed documents. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is option B. Courts require a concrete legal basis for intervention, which means alleging a clear, non-discretionary duty and requesting specific relief. Simply describing the delay or hardship, while sympathetic, does not satisfy the pleading standard. Additionally, consider these steps before filing. First, exhaust non-litigation options such as service requests, congressional assistance, and expedite pathways. Second, document your timeline and preserve evidence of all contacts and responses. Third, consult a qualified attorney early, even if only for strategic guidance. Fourth, study federal pleading standards and your court's local rules. Fifth, identify the specific legal duty that is non-discretionary and the exact relief requested. Finally, anticipate likely motion to dismiss arguments and plan a response. Now here is a concise, markdown-style pre-filing checklist. First, try non-litigation options such as service requests and congressional inquiries. Second, consider whether you meet expedite criteria and gather evidence. Third, organize a delay timeline with supporting proofs. Fourth, identify the clear, non-discretionary duty you allege. Fifth, draft the precise relief sought, which typically compels a decision rather than dictates the outcome. Sixth, review local rules and formatting requirements. Seventh, schedule an attorney consultation if possible. Before we proceed, here is an important disclaimer. This video provides general educational information and does not constitute legal advice. Laws, procedures, fees, and timelines can change and vary by jurisdiction. You should consult a qualified attorney regarding your specific circumstances. Examples and figures used here are illustrative only. To recap, a writ of mandamus is a federal lawsuit requiring a legally grounded complaint. The pleading must allege a clear, non-discretionary duty and request specific relief. Underdeveloped complaints invite motions to dismiss. Professional representation can mitigate risk, and applicants should weigh attorney costs against ongoing lost wages and the complexity of federal litigation. In summary, understand the legal standards before filing, prepare for government pushback, and consider engaging counsel early to avoid critical errors. Track both direct and opportunity costs, including lost income, and use checklists and timelines to maintain organization throughout the process. Finally, thank you for watching. If this video helped clarify the risks and realities of mandamus actions over processing delays, please like the video, share it with someone who needs it, and subscribe for more explainers. In the comments, tell us what part of the process you want us to unpack next.